Ayana, I'm seeing Justice Kukaram in the waiting room. I'm going to let him in, okay?
No problem.
Or did he come in already?
I let him already. I'm ready.
Oh, okay.
Is it just testing? Good morning,
Hi,
everyone.
Justice. Good
Good
morning.
morning. Good morning. Good to see you all. All right, so we'll be good here with this background and everything.
Do you want to change it? Can you change it, please, to our background?
All right, so I have to, you sent it to me.
Nikisha would have sent it to you.
Oh, okay.
It was in the email with the agenda.
Sure. Link for the meeting or Zoom background. Okay, right.
Mhm.
Good morning, Vashish Kukaram. How are you?
Who's this? Who's this talking? Let's hold on.
Beverly.
Bevy.
Welcome, everyone. Good morning and welcome to the Ministry of Sport and Community Development, Community Mediation Services Division, Public Education Mediation Conference. Our topic over these 3 days are building a collaboration in conflict resolution, a transformative approach to mediation. I just want to welcome all of our participants as they come into the room. I also want to welcome those who were here yesterday, as well as our presenters today into the room. We really appreciate all of you who are here to make this event a success. Today, we are going to be talking about a Caribbean perspective, current experiences focus on solutions for the future. Now, I know yesterday we would have heard from agencies in Trinidad and Tobago, from Community Mediation, the host of this conference. We would have also heard from the Equal Opportunities Commission, as well as the Hugh Wooding Law School. And we really would like to remind ourselves of all of the information that was shared yesterday. You can go on to the ministry's website, as well as the YouTube page that was shared as well. We encourage persons to get your notebook out, get your papers out, take some notes, share the information with someone who was not able to register, right? And also contribute in the chat, or we will also have the opportunity after our panel discussion to ask questions. Today, our format will be a little bit different. We will have breakout rooms because we want to hear from you. How can we change or create a wider awareness of the role that mediation can play in transforming the community? So we are having breakout rooms where persons will be able to answer questions, and we'll hear from you what we can do in the future. And as you see represented here are persons from the entire Caribbean region. So today, I'm very excited because I have a co-host with me. I have Justice Kokoram with me. So I would now do an introduction for Justice Kokoram. So Vasish Kokoram is a judge of the Court of Appeal of Trinidad and Tobago. He previously served as a judge of the High Court from 2009 to 2020. Prior to his appointment to the bench, he was a partner in the law firm M.G. Daly and Partners, specializing in industrial relations, public law, international trade, and mediation. He was also a community mediator appointed under the Community Mediation Act from 1998 to 2005. He served as a temporary High Court judge in 2006 on a backlog reduction project in which he began the use of judicial mediation. Justice Kokoram was the chair of the Court Annex Mediation Pilot Project in 2010 and currently a member on the ADR Implementation Committee in the Supreme Court of Trinidad and Tobago. He is a certified judicial trainer, UCL Judicial Institute. He has conducted JSC sensitization and training sessions for registrars and judges. He is also a judicial settlement officer from 2009 to date, conducting judicial settlement conferences in commercial, family, and appellate matters. Justice Kokoram was the chairman of the Mediation Board of Trinidad and Tobago from 2010 to 2018. As chairman, he advocated the use and application of mediation as a means of developing a more peaceful and productive society. He led several public educational campaigns on mediation from 2010 to 2018 at the board, which convened several national annual mediation symposia and produced publications on mediation and certification. He has been an associate tutor at the Hugh Wooden Law School from 2005 to date. Currently, as a tutor in civil practice and procedure, he promotes the development of settlement plans as a key component in the attorney's pre-action case and case management strategies and the development of collaborative law practices. In March 2022, he launched the Peace Jurisprudence Clinic, the Healing Hub, as a component of the students' legal aid clinic at the Hugh Wooden Law School. He has made several presentations to judicial and legal workshops and conferences. So I would now like to invite my co-host and advocate for mediation in Trinidad and Tobago and across the region, Justice Kukaram. Good morning. So some technical difficulties, but Justice Kukaram is going to be bringing greetings to us. And he will be given, unfortunately, he's unable to.
Hold on. There we go. All right.
Go.
Yeah, there we go. All right. Excellent. Technologically challenged, Miss Williams. Thank you very much for that very comprehensive introduction. And it is such a delight to be part of your conference, and especially in this panel discussion and co-hosting it with Renee, whom I know for such a long time. In fact, the panelists are no strangers to us in the mediation community. These are champions of mediation. And I wondered about that word about advocates of mediation. I find when we use the word advocate, we might think about someone in the courtroom. So maybe champions of mediation, and that's Miss Beverly, Harry, Emmanuel, and Rennie Batiste, and John Bassi, and Deborah Maloney. And I'm not going to take up much time, Ms. Williams, on my soapbox, but it's so good to have these Caribbean specialists here. And I just want to make 3 points, maybe as an opener, Ms. Williams, and maybe can filter throughout the discussions. But first, we're talking about a Caribbean perspective, and many of us in the mediation profession would have developed and learned our techniques from Canadians, American courses, from the UK courses, European courses. It's so important for us to develop our own style, our own Caribbean instincts. We have our own instincts of peace. There are no better peaceful and hospitable people than the Caribbean people. So it'll be interesting to see what techniques we are developing that is indigenous to ourselves, with that rich history that have brought us together as a Caribbean people to be a peaceful region. The second thing is that in our topic, we talk about current experiences focus on solutions for the future. Future solutions has to be sustainable solutions. So it'll be interesting to see what our dialogue will be on sustainable solutions. Speaking for myself as a judicial mediator, that is an interesting concept coming through the Caribbean, where judges are now mediating. That has been planted on the theme of sustainable development and looking for sustainable solutions. No longer should the judiciary be interested in just simply ending a conflict. We should be interested in learning from our conflict, building on our conflict, embracing a conflict, and transforming lives from conflict. And that is one of the beautiful things of mediation, and in fact, transformative mediation. And it's important for us to develop that style of transformation through mediation, to develop that language and that understanding, which will promote sustainable development. And I usually use the words, the 3 C's of mediation, which is transferable from the process into our lives: compassion, collaboration, and consensus building. And finally, when we speak about the idea of embracing conflict and not running from it, we have to look at conflict really as part of our lives, and in learning from it, we are actually trying to develop pathways to peace And I think once we start thinking about mediation as a pathway to peaceful living and peaceful development and visions of peace, I think it's important to tie in the mediation process with peace. If it's internal peace, if it's peace between parties, if it's creating conditions, human conditions for peaceful development. I think that is a strong thrust for mediation. And so there is a thought out there by David Augsburger about conflict, and I want to adopt his word, which is not to confront conflict, but to carefront conflict, and to embrace it with care, compassion, action, relationship building, and empathy. So those are some thoughts I'd just like to leave with you. It might filter through the discussion, but Ms. Williams, thank you very much for inviting me, and I really look forward to what our distinguished panelists will have to say this morning.
Thank you very much, Justice. And I really, as you said, I'm also looking forward to hearing about sustainable solutions. So that is something that we can look at in the breakout room, right? Because when it is we talk about communities, we talk about sustainable community development as we are under the Ministry of Sport and Community Development, but we also want to talk about sustainable things that can last throughout generations and not only in this generation that we are in. Right? So I just want to remind our participants who are in our rooms today of the procedure that we will go through before we go into our discussion and then our breakout rooms. So first, I will read the bios of the participants who are going, the panelists, sorry, who are going to be presenting today. And then we will have each panelist present, and then we'll have our panel discussion. After that, we will go into the breakout rooms where we will hear from you how we can create sustainable solutions for the future, talking about future implementation of mediation throughout the region. And then we would have the presentations from each of the rooms before we finally go into our question and answer segment from the participants. That does not mean that you will not get the opportunity to put your questions into the chat. And so we encourage persons to put your questions into the chat or take notes so that when it's time for the question and answer, you can raise your hand and ask a question. So it is giving me, I have great pleasure in going through the bios of our panelists today. So firstly, we have Ms. Beverly Harry Emmanuel. Mrs. Emmanuel has an excess of 28 years of progressively responsible experience in human resource management, administration, sustainable development cooperation, in addition to program and project management. Mrs. Emmanuel has held the position of technical advisor in the United Nations Development Program, as well as project officer in the Caribbean office of the International Labour Organization. As a former executive director of Community Mediation Services Division, she has executed the cabinet decision to implement a system of community mediation in Trinidad. She was responsible for policy prescription and the planning which was necessary for the establishment and management of community mediation program. Additionally, Mrs. Harry Emmanuel drafted the community mediation regulations that was later passed in Parliament, which together with the Mediation Act formed the legal framework for the work of the community mediation program. Additionally, using a strategic leadership approach, the division implemented several proactive programs, including the Parent Support Group Program and the Peer Mediation Program. Mrs. Emmanuel is a former member of the Mediation Board of Trinidad and Tobago for 3 consecutive 3-year terms. She is a certified mediator in Trinidad and Tobago in civil and non-family matters, as well as family matters, and as well a certified mediator assessor with the Center for Effective Dispute Resolution. Beverly Harry Emanuel is the holder of a MSc in Strategic Leadership and Management with distinction, a postgrad certificate in Business Management, and BSc in Sociology and Management, along with several other development certificates. So we welcome Ms. Emanuel. Next, we have Mr. John Bassi. Mr. Bassi was nominated and elected as the Global Vice President of CIARB for 2021. He was also the Deputy President in 2022 and is now the Global President in 2023. He is called to the bar in England and in Jamaica. In addition to being a former council member of the General Legal Council, he was the chairman of its subcommittee with responsibility for the formation of the Compensation Fund. John is the president and formerly served as vice president and treasurer of the Jamaica Bar Association, and he was formerly chairman of the ADR committee. John is the founder of the Caribbean branch of the Chartered Institute of Arbitrators, formed in 2009, and the first chairman of the branch. He is also chairman of the board of the Dispute Resolution Foundation, which is the oldest ADR organization in the Caribbean region, having just celebrated 25 years of service to the industry. He is a chartered arbitrator, certified tutor of the Chartered Institute of Arbitrators, and a certified mediator of both the Supreme Court of Jamaica and the Supreme Court of the State of Florida. John has taught and handled ADR disputes in the Caribbean, North America, Europe, and Africa over the past 2 decades. Next, we will have Ms. Deborah Maloney. Ms. Deborah Maloney presently serves as a regional mediation coordinator at the Eastern Caribbean Court based in St. Lucia. In this position, she is tasked with coordinating and managing court-connected mediation activities in the 9 member states and territories within the court's jurisdiction, namely Anguilla, Antigua and Barbuda, and the Commonwealth of Dominica, Grenada, Montserrat, St. Lucia, St. Kitts and Nevis, St. Vincent and the Grenadines, and the territory of the Virgin Islands. Ms. Maloney is an attorney at law trained in mediation advocacy and is also a certified mediator. Therefore, she has fully embraced the tenets, goals, and objectives of mediation. Further, she is passionate about the propagation of mediation as a tool towards the empowerment of persons of diverse realities who find themselves in disputes. Ms. Maloney also holds a BSc in Management Studies with a minor in Finance and an MSc in Strategic Leadership and Management, both from the University of the West Indies. And our final panelist is Ms. Renee Batiste. Ms. Renee Batiste is a barrister, solicitor, notary public, and certified mediator. She was called to the bar of St. Vincent and the Grenadines in October 1976 and opened her solo law practice in 1986, which specializes in contract law, company law, corporate law, shipping law, employment law, property law, family law, and trademark registrations. She has written about 10 articles in professional publications between 1980 and 1990s, mostly on international business. The first female lawyer to be elected to the Parliament of St. Vincent and the Grenadines in 2001, and serves as a senior member of cabinet holding portfolios in tourism and culture, as well as in urban development, culture, labor, and electoral matters. Additionally, she is the first and only speaker of the OECS House of Assembly since 2012. In 2018, Ms. Batiste was certified as a mediator. In 2020, Ms. Batiste was certified in corporate governance, chairman course and in 2021 obtained an LLM certificate in corporate governance from the Faculty of Law, University of the West Indies, Mona. Ms. Batiste was elected to the board of directors of the largest credit union in St. Vincent and the Grenadines and served as secretary, vice president, and the president. Currently, she serves as chairman of the board of the largest public company, St. Vincent Electricity Services Limited, which has over 44,000 customers and is a member of the National Energy Committee. Ms. Batiste has also served in leadership positions under St. Vincent and the Grenadines Girl Guides Association, St. George's Cathedral Parish, Island Council and Diocese, and the St. Vincent and the Grenadines Red Cross Society. So I would like to welcome all of our panelists today, and we will start with Mrs. Beverly Harry Emmanuel. Mrs. Emmanuel.
Thank you, Renee. Let me just share my screen. Yes, this is my presentation now.
Not as yet. It's loading.
Okay, great. So in the meantime, good morning to the host of this morning's proceedings, those in the organizers, the persons working in the background, and all the listeners and viewers. Let me see, is it, let me share. I'm not seeing my presentation yet.
We are seeing it.
Yes, okay, fantastic. So good morning. So let me proceed then. Now, if you were to ask anyone about Trinidad and Tobago, you would hear very likely about our peoples and our cultures, and that we are a melting pot of many of the world's peoples and cultures. The two largest groups of our people, though, are the descendants of the African slaves and the Indian indentured workers. And they have been anchored, or they were anchored, and we are anchored on the rich and enduring culture of the first peoples of Trinidad and Tobago. Now, these indigenous cultures of our ancestors all have rich, well-established systems of conflict resolution that involve elders, chiefs, and religious leaders, among others. And these systems were based on trust, confidence, respect, authority, and the recognition that conflict was a communal issue. Therefore, community stakeholders were an integral part of the resolution of conflict. And these traditional cultures of conflict resolution promoted consensus building. They emphasized the emphasized the maintenance of the social fabric of the village or the community and ensured social order. But I'm sure you've heard of some of these institutions, such as the Council of Elders and the Panchayat. The benefits of these institutions, as I would like to call them, these traditional conflict resolution structures, they served those communities well to maintain the efficacy and viability of the social structures of their communities and their countries. Unfortunately, many of these benefits have been lost to us today through slavery and indentureship, and replaced by Western legal systems, which largely exclude the community from the resolution of conflict and the restoration and maintenance of peace. Placed in this historical context that I've just painted, it should be no surprise that the community mediation pilot held between 2000 and 2003 yielded promising results. The outputs and outcomes of the pilot project and the subsequent public consultations suggested that mediation in Trinidad and Tobago was feasible. However, new structures were required and a new legislative framework which provided for referrals to the court system, or from the court system, sorry. I believe that it was at the very first mediation conference hosted by the Mediation Board that I presented on changing our conversations through mediation. And I shared my vision that over time, community mediation would work itself out of a job because everybody would have learned how to manage and resolve their own conflicts, because the ethos of mediation would have become so pervasive and second nature to individuals. So the theme of this conference suggests that the dream is still alive. So thank you, Rennie, and community mediation. This ideal, however, guided the approach adopted in designing and implementing the structures of the community mediation program. And this ideal is in essence a transformative approach to mediation, when we can all do it for ourselves and do it to build peace. A transformative approach to mediation must include two key elements: conflict management strategies and tactics to instigate change and behaviors and attitudes towards conflict through education, information, advocacy, and inclusion, to encourage and develop competencies to navigate difficult circumstances and resolve conflict. And the second component, equally as important, is the conflict resolution system or process to address existing conflicts. And yesterday, the executive manager of community mediation would have shared those components of community mediation with you. Now, according to COTS, conflict management in general and conflict resolution in particular are almost entirely determined by understanding of a conflict and not only by the symptoms. So we must admit that conflict is unavoidable and necessary for the generation of new ideas and solutions that enable society to grow and develop holistically. But it is often considered to be a bad thing. This perception stems from a pervasive unpreparedness to confront or carefront conflict and to harvest its benefits. It is through conflict that new solutions to pressing problems are derived. Now, although this country of Trinidad and Tobago was born out of cultures steeped in strong oral tradition and proven indigenous systems of conflict resolution, we have lost to a great deal the art and skill of debate and useful conversations that build rather than fracture. So when a problem arises, we often adopt a posture of aggression and avoidance, and increasingly, we are becoming more and more litigious. The result is we lose the potential benefits that could have been derived from carefronting and ventilating issues in a useful, positive, and constructive way. Mediation skills and the adoption of restorative practices when carefronting and facilitating hard conversations are powerful tools with the potential and capacity to transform our conversations and quality of life. So as we embrace the transformative benefits of mediation, we must create structures that encourage and support hard conversations that are inclusive, civil, truthful, focused, and constructive. We also need to teach and encourage the development of skills required to listen to difficult conversations, especially when we are the focus of those conversations, and to deliver hard and to hear hard truths. We also need to increase the opportunities for community engagement, for community input and involvement. We need to engage our communities to find out how communities are seeing themselves as being an integral part of the conflict resolution process. We need to use different forms of media to engage as many people as possible. Now, social media is great. We can reach many people at a low cost, but we have to remember that there is a value of teaching and information sharing, and that many people are not on social media. So we must embrace and continue to use mainstream media as well as we share the information and we teach and encourage people to change the way we view conflict and we manage conflict situations. Equally as important as community engagement is building and maintaining strategic collaborative relationships with stakeholders and other organizations. And these must include private, public, regional, and international agencies. The very nature of mediation is collaborative problem solving. And I am challenging anyone in the audience to tell us via the chat about a successful mediation that they would have achieved when there was just one party at the table. So there are many benefits to collaboration. It increases the wealth of ideas. It increases the availability of competencies. It increases goodwill and recruits champions. It increases the quality and quantity of available resources. It increases exposure to the nature of conflict management. It increases trust and confidence in the programs that we offer. It increases confidence in the individual agencies so that success is inevitable. It increases visibility. And I am sure my list is not exhaustive. Ladies and gentlemen, I would like to propose a challenge to supercharge the transformative benefits of mediation. I am encouraging steps to pursue social research and community engagement to identify and understand the root causes of the pain points of the population, harness the wisdom of our ancestors and the indigenous structures, conflict management structures that they utilize, and create structures and programs that are designed, built for our cultural realities. Now, we know that mediation teaches transferable skills. Yesterday, I heard some panelists speak about how mediation transformed their lives. I too can attest to that. It changes you in many positive ways. So I would like to present to you or offer to you and leave you with a different perspective, a perspective about employing the negotiating, problem solving, and conversational skills learned through mediation outside of the context of conflict to stimulate and energize participatory generation of ideas for social and economic development, creativity, and entrepreneurial mindsets for community and nation building and region building, because that's the power of mediation. And finally, with individual commitment and effort, we can change the nature of our collective conversations, I am sure of it, towards a gentler, more peaceful, productive society. I believe that we're at the cusp in Trinidad and Tobago. We are at the cusp, the foundation has been laid, the runway has been cleared, and mediation in Trinidad is ready to take off. Thank you, Renee, for the time.
Thank you very much, Ms. Emmanuel. And I just want to welcome that challenge, and I hope that our audience took note of that challenge, right? So we are going next to Mr. John Basie. Mr. Basie. Okay, so while maybe we can go next to Miss Maloney. Miss Maloney? Okay, thank you, Miss Maloney.
Oh, I'm sorry.
Good morning, everyone. Is
morning.
Mr. Basie ready now? Should I go?
Yes, I thought I was third. I apologize. Yes, I'm ready.
Okay,
Okay.
so let
All
me
right.
stop sharing.
Yes. Right, you can go ahead and put on your camera and share your screen.
Okay, appreciate it. Good morning, everybody.
Good morning.
Right. Okay. Yeah. Trying to
So we are seeing your screen, but it's not in presenter view.
Yeah. Slideshow. And great. How are we doing? Good morning, everybody. Let me first thank you for having me here this morning, and with such a distinguished panel and audience. I will scroll through it, and also thank you very much for allowing me to participate and share what I'd like to say is a Jamaican experience. I'm hoping that we're able to at least see what we're doing in Jamaica. It's not dissimilar from what else is happening in the Caribbean. We may have been at it a little bit longer, and we can see the path we've taken and what's been evolving over, I would say, probably the last 23, 20, maybe longer than that, probably about 25, 30 years. So let's see what we've got. We know what the mediation process is. It resolves disputes, it's a third-party facilitator, and of course negotiates between parties with a view of resolving the dispute. We have an idea of what favors mediation, and I'm not going to keep repeating what's been said before, but of course it avoids publicity, speedy resolutions, recognition that hostility may bar settlement, and a need to reduce the high cost of litigation, which is critical. And of course, there's the existence of collateral issues that identifies these issues and allows parties to really look at the core issues and work towards some sort of settlement that is sustainable, as Vash had said earlier, Judge Coker has said earlier. I want to talk a little bit about mediation in the courts in Jamaica. Now, we know that the idea behind it is to reduce caseloads, improve the pace of litigation, and of course, reduce cost to litigants and the court system. And when you use mediation basically what it does, or dispute resolution mechanisms, it allows parties to really work with the situation and of course, ultimately reduce the backlog of cases or the backlog of cases in the court system. And of course, this saves everybody time, energy, and money, and ultimately improves the access to justice. In Jamaica, we have court-ordered mediations, and of course, there's clauses in the contract that requires parties to mediate. And of course, we also have mediation at different stages in the litigation process. When parties fail to mediate, we also have the ability to for cost sanctions. When one says failure to mediate, you can't force persons to mediate, but at the very least, if you are ordered to mediation and you have a good reason not to mediate, that's one thing, but to totally disregard the system is another thing altogether. I should note also the country and the court system is in full support of mediation and encourages parties to mediate, especially where the jurisdiction does not allow the court-ordered mediations. There are several pieces of legislation that deals with court-connected mediation in our region. The Adjudicator Resident Magistrate Court, and we'll talk about that a little bit later on. The Criminal Justice Reform Amendment Act 2001, and Part 74 of our Civil Procedure Rules of the Supreme Court, which actually speaks to automatic referral to mediation. And I'll mention that a little bit later on as well. It's very important you understand it's not mandatory mediation as you are hearing that term bandied about, especially in England and Europe. But we have automatic referral to mediation, which pretty much means that once you go through the process in the Supreme Court of a claim being filed, a defense being filed, and then of course at that juncture you are referred to mediation. What it basically means is that you might be able to not go to mediation if you've got a very good reason, but you need to make an application to dispense with it. On your screen, you're seeing three figures: 67, 42, 13. Any idea what those are? I'll give you maybe 30 seconds of my presentation time to see if anybody in the chat can give me a quick guess as to what that means. 67, 42, 13. Any takers? No? All right, let me tell you what that is. Though that is the number of judges that we have in our system at the parish court level, Supreme Court level, and the Court of Appeal level. So when you add that up, my math's correct, you're looking at 109, 122, something like that. What you're looking at is the number of judges that are dealing with the number of cases in our system. So if you do the math by itself, you can realize that it is really an uphill task. So therefore, dispute resolution mechanisms are very critical to our system. The goals of Part 74 automatic referral to mediation, it improves the pace of litigation, and of course promotes an early and fair resolution of disputes. And the cost of litigation to the party to reduce the costs. Because once you take a matter out of the system or it is resolved, it saves everybody time and money. I've always said that if you were to look at a case that has a beginning and a finite end, there are certain fixed costs you can apply to that. Judges' time, judicial officers' time, litigants' time, attorneys' time. There's a value there. And the quicker you're able to resolve that, you will be saving time, energy, and money, ultimately, the citizens of the country. It improves access to justice, very critical. And of course, satisfaction with the dispute resolution in the justice system is also a good indicator of a place to do good business, and also puts you on the path to a change. Now, we look at the mediation practices in Jamaica. The Dispute Resolution Foundation was appointed the mediation referral agency under Part 74. What that basically means is that the DRF, which has been incorporated actually for 28 years, and before that was the mediation board, basically organize the mediations within the system. Once a party goes to court and they're seeking a mediator, the DRF will step in, and you'll choose your mediator and they'll schedule and appoint everything. Parties are given 35 days to initiate the mediation process, and failure to do so, the DRF will be able to appoint. Part 74 also outlines the process to guide mediation at this level. If an agreement is reached, the court will make an order in terms of the report. If no agreement was made, or no mediation took place, then a case management conference is fixed. Failure, as I said before, to attend mediation may result in a claim or a defense being struck out on application by the other side. Now, I'm looking also at the types of court mediation. We've got parish court and Supreme Court. In the parish court, we're able to do certain criminal matters, unlawful wounding, and they're listed here, assaults, and assault occasioning bodily harm. And of course, these are matters whereby parties will come to court and the judge will offer the parties mediation. Civil matters, protection orders, recovery of possession, and of course, family matters, custody maintenance, and other matters under Towns and Community Solid Waste Management and Noise Abatement Act. The Supreme Court, all matters arising in civil jurisdiction, fixed rate claims are not supposed to, and I say supposed to because sometimes they are mediated, and of course writs of habeas corpus, bail applications, non-contested probates, and the list goes on. Those are called the exceptions. Let's look at a little bit at our mediator training in our country. We have an advanced mediation training program where persons who are hoping to enroll as an advanced mediator has to complete first and foremost a 40-hour basic training. Having done that, he or she completes practicums and have obtained a certified mediator, and then becomes ready to do a number of mediations over a period of 6 months. To be eligible to be added to the Supreme Court roster, the Chief Justice will gazette those persons who are able to show previous certification, mediation training, the experience, the 40-hour training program, completed the advanced mediation training, and have conducted at least 10 parish court mediations independently, being observed by a Supreme Court mediator. And of course, to apply, candidates must submit the completed application form, resume, 2 pictures, 2 passport pictures, and copies of mediation certificates. All the applicants will be interviewed by a panel for fitness. Basic mediators training is delivered online over a 7-day period. And of course, that's most been recently added. And basically what that means is that we're able to do training online now. And this course has a theory and a practical component. The theory is 1 to 5 days, over day 1 to 5. Practical days are 6 with role plays. And we do in fact use actors from Edna Manley Visual Arts with different scenarios in order to ensure that parties are able to learn their skills and be able to be critiqued. Of course, the core areas of effective conflict resolution, we speak to elements of conflict, cause of conflict, conflict and its management, negotiation, mediation, arbitration, mediation skills, and of course, the 7-stage mediation model. Negotiation strategies, agreement writing is very critical because sometimes you're in there with parties who aren't really au fait with writing a document that the judge will be able to appreciate and, of course, ratify. As I said before, training, we have justice system actors trained, and of course, expanding group of trainers. We have new skills for attorneys and judges. We have organized arbitral services in conjunction with the Chartered Institute and a development of service rosters. And of course, these all have to adhere to standards and protocol. Now, at our Norman Manley Law School, we have a program which offers an introduction to ADR in the legal profession, what's conflict, the cost of conflict, role of judges, attorneys, disputants, and of course, the role of the mediator. As you can see, our journey is taking us along a line as we grow and evolve. And of course, there's no magic to it. Sometimes we have to, as we say in Jamaica, stop, look, adjust, and wheel and come again. But the journey seems to be taking us in the right direction. Okay, the 21st century attorney will look at mediation, case management, and trial. And the legal profession will also look at the court, the Supreme Courts, and of course, resident magistrate courts. Preparation, negotiation, pre-trial, and arbitration. In other words, we have to be able to recognize that as attorneys too, we are dispute resolvers. We're not just attorneys, we're not just litigators, and it can't be one size that fits all. So in discussing with our clients, it's very important that we speak to them and let them know that there are options, and along the process, as we move forward, there will be opportunities to resolve the dispute before getting to the trial. And prepare your client, educate them. The role of the judge and the court staff in the 21st century to advise disputants, lawyers in the court to have a working relationship with the relevant mediation agencies and to explain the process. It's very important that we maintain and manage records of cases in the mediation system. This I find to be very important because this sort of information can be shared, results shared, and we can identify areas that we can improve on or increase on. So what are the role of our lawyers? Before the mediation lawyer should advise the party about the process, help the parties to select a representative, and brief the party representing the case. Let them be aware of what is being offered here. It is not litigation. Hello? It's not litigation, but it certainly can assist us.
And Mr. Bassi,
Yes.
so we want to thank you for sharing on the perspective in Jamaica. I really want to thank you as well for clarifying that it is not mandatory mediation. We would have discussed that yesterday, and the case that you brought up, Dr. Devines also would have brought up. So we would thank you very much for sharing your screen as we go to the next panelist. And hopefully you'll be able to bring up some of the points in the panel discussion.
Just before I go, Ms. Williams, one thing I wanted to say at the end, if you permit me for 10 seconds.
Yes.
I want third parties to recognize, especially our audience, I would never not say this to a group if I get the opportunity. Mediation is a game changer. It is a game changer with our students, our communities, our court systems, and the way we do business. And it's a cultural change that we should all adhere to and shift towards. Thank you very much for having me this morning.
Thank you very much. We will now go to Ms. Maloney. Yes, who is representing the Eastern Caribbean Court. Ms. Maloney.
Good morning, everyone. And thank you so very much, Ms. Williams.
You're welcome.
Let me congratulate the division on hosting what seems to be so far a very successful conference. And thank you as well for the work that you do. I would like to especially recognize Justice Kokaram, who has been an avid supporter and helped us in the Eastern Caribbean. Any other member of the judiciary who is on the platform. My colleagues, of course, who are panelists, especially Ms. Batiste, who is also from the Eastern Caribbean, and everyone else who's here. Oh, I also want to especially recognize all those persons from the Eastern Caribbean. I've been seeing some of them popping up who have joined us today. So thank you so much for the opportunity to be here and to deliver this short presentation. So the topic that I have been asked to present on is the Caribbean perspective, current experiences focused on solutions for the future. Before I get into it, I just want to give a brief background on the Eastern Caribbean Supreme Court. The court was established in 1967 with the statutory instrument listed there. And you will observe what the initial logo looked like. And if you look to the far right of my screen, to the top, you'll see what our logo looks like now. And these two listed here, are, of course, our predecessor courts. So a little bit about the mediation program in the Eastern Caribbean. So the mediation program was formally implemented in the 9 member states and territories of the Eastern Caribbean Supreme Court in 2003, and is now a very well-established alternative for resolving disputes. We do not have a mediation act unlike Trinidad and Tobago, but we are governed by Practice Direction number 6 of 2020, Court-Connected Mediation, number 7 in the case of St. Vincent and the Grenadines. Despite the length of time that we have had mediation in existence, we are still faced with several challenges. And as we focus on solutions for the future, my focus for this short presentation will be the challenges faced in the Eastern Caribbean Supreme Court, our civil mediation program, and solutions in mitigation. So what are some of the challenges facing us? I have quite a few of them listed here, and these are not all of them. Please take a good look at these challenges, because I will invite you, when I go to my solution screen, to put in the chat the challenge which that solution intends to address. So the first one we want to look at is legal practitioners. Yes, that is a challenge. We do have several legal practitioners who are mediators in the Eastern Caribbean, but yet still we have found that many times mediations are postponed or canceled because legal practitioners do not make themselves available. And the clients are many times hold the belief that they cannot attend the mediation without a legal practitioner lawyer in attendance. And that is not the case. We try to stress all the time that a lawyer need not be present, but when I get to one of my other challenges, we'll understand why persons tend to still hold the belief that a lawyer must attend in order for them to go to mediation. Legal practitioners, many of them, and I have to say not all, seem to believe that ADR in general and mediation in particular takes away revenue, their revenue generating ability. So they are not supporters of matters being referred to mediation. And this is something that we definitely have to work on more. in the Eastern Caribbean. So when I get to my next slide, you will see what we hope to do to address this challenge. Another issue with legal practitioners is that many times when the matter is referred to mediation, legal practitioners advise their clients not to sign the agreements. And that leads to another challenge, which is the appearance of a settlement during the mediation. And then when the matter returns to court, there is a party saying, well, I did not agree, and refusing to sign. So there's an issue we're faced with in terms of our legal practitioners. Another challenge I want us to consider is the cost of mediation. You are very blessed with your community mediation program in Trinidad and Tobago. If I am correct, you do not pay. I think I observed that there's a payment applicable if there's a translator also involved, or if the parties themselves request an expert. But aside from those fees, in the Eastern Caribbean, parties are required to pay fees. They are required to cover the cost of mediation. And while we try our very best to keep it reasonable, there are still those persons who find the fees to be, a bit much and out of their reach. So the cost of mediation is also another challenge that we are faced with, and which we have measures in place to address. Now, evaluating the mediation process. We will all agree, having understood what mediation is all about from my previous presenters and because of who we are on this platform, that evaluating the process is critical to the success of any mediation program. We want to be sure that the goals that have been set out are achieved. And the only way we can do so is if we properly evaluate the process, and then we go back and we tweak so that we achieve better outcomes. However, in the Eastern Caribbean, while we do have evaluation forms to evaluate the process, particularly to evaluate the performance of the mediator, we are challenged in terms of getting legal practitioners or the parties to complete those forms. And this really, has been an issue for us. So we have been compelled to institute some measures in order to combat this. Appointment of mediators. I was very interested to see that in the community mediation process in Trinidad, the manager is the person who selects the mediator. Our experience in the Eastern Caribbean is very much different. In the Eastern Caribbean, it is the parties, particularly through their legal practitioners, who select the mediators. In fact, they have the opportunity to select 3 mediators, the main one and then 2 alternates. And what we have found happening in our jurisdictions is that just a handful of persons, a handful of mediators are being used over and over and over. And this means that although we have a roster with several mediators, there are persons who may have completed the training, been placed on the roster, and for many, many years have not been granted the opportunity to conduct mediations. And the saying goes, if you don't use your skills, you're liable to lose them. So the appointment of mediators has really been a challenge. That also poses a challenge because when one mediator carries too many cases, it in itself leads to delay and backlog, which is something that the mediation process is designed to combat. So the appointment of mediators has really been, our system of appointed mediators has also been a challenge for us in the Eastern Caribbean. Now, I don't know what happened in Trinidad and Tobago, and perhaps I will learn what happened in our breakout room session during COVID-19. Did you all have online mediation sessions? Well, we surely did. In the Eastern Caribbean, we introduced virtual mediation. It was happening on a small scale, but it took off during COVID-19 to ensure that mediations could continue and so that the court's backlog didn't worsen. And in fact, in some of our jurisdictions, virtual mediation is still the order of the day. Some of them have not yet returned to in-person mediation. But now, with this new system being used, this new format, we have a new challenge, which is how do we police confidentiality? And this is one of the questions that I want us to keep in mind when we go into the breakout rooms. How do we police confidentiality in a virtual setting? Do we know if there's somebody who is not in front of the camera pulling the strings of the litigant or the disputant? Do we know if somebody who is not permitted to be a part is listening in? So we have several challenges, forms and so on that need to be submitted. Sometimes we have delays in them being submitted because persons are attending virtually. So we will discuss how this may be addressed. And again, I invite you to bring your ideas in the breakout room. Inadequate public education and awareness. Now, we do have some really great promotional materials. We have a wonderful animation, which if I had more time, I would share with us. We also have a wonderful jingle created by the Mediation Committee in Antigua and Barbuda. A wonderful jingle, mediation jingle, which I also wish I could have shared. But despite these efforts, they have proven to be inadequate, and most people are not aware. Most people are not aware still of what mediation is, even professionals. You know, the other day I went to the dentist and I had to explain to her what mediation was all about. So there's still a great need for public education and awareness so that mediation could take its rightful place. So next slide, now we will look at our challenges. So I invite you, our solutions. So I invite you to put in the chat the challenge that solution addresses. Okay, so electronic evaluation forms. Please put in the chat what this has been designed to address. So we have now developed in the Eastern Caribbean electronic evaluation forms to improve the process for completing evaluation forms. This, despite the introduction of electronic forms, the challenge persists. Those of you who are joining me in Breakout Room 4, keep this in mind, please, as one of the areas for discussion. How do we get people to fill out forms? So we have tried to provide a solution, make it electronic, 5 minutes and you're done, still having challenges. So we have tried to put forward a solution, but we're still working on it. The court provides for pro bono sessions. What challenge is this providing for? If you remember what that challenge was, please put it in the chat. So although we try to keep our fees reasonable, we do provide for impecunious litigants or disputants who may apply to the court. They have to do a means test so that their fees are waived. And in fact, our mediators are required to give 12 hours of pro bono services annually. Webinars will be held with respective law associations and their membership to bring legal practitioners on board. And fortunately, I have become connected with mediators from across the world, so I hope to bring some of them in so that these webinars may be held with the law associations. One of the things we've also done is we have asked the law associations to share the bios of the mediators so that selection can be broader and not as limited as it has been. A system of appointment by rotation. This is a possibility for the future. So we would have discussed the challenge, which I hope you're putting in the chat. And in order to address this challenge, this is a solution that we want to introduce in the Eastern Caribbean. It's not yet approved, so that's why I have a possibility for the future. So in the future, mediators may be appointed by rotation, but of course, there will be provision in our practice directions for the judicial officer to select a specific mediator where circumstances require. Sometimes you need special, particular expertise, experience, and so on. And that will not be, done away with because we have a system of rotation. Return to in-house mediation sessions where necessary. So if we still have challenges going virtual, then this may be the only solution. for now, if anybody who is techie and think they have some brilliant idea in terms of how we may preserve confidentiality in that virtual setting, I look forward to meeting with you to discuss those in the breakout room. But for now, if we're not able to, have successful mediations virtually with respect to confidentiality issues, then we may be compelled in all cases to return to the in-house session, which really is my preference. I believe that the in-house in-person session is ideal.
Ms. Maloney. So,
yes.
Yes. So thank you very much for sharing the challenges. And I see some similarities with community mediation as well as with Jamaica as well. So any closing words as we prepare for our last panelist, Ms. Batiste?
Yes, I just want to encourage us all. Sometimes we have these skills and we just, we hold on to them. We don't encourage people to use mediation skills. So I want to challenge each person who's on the platform to tell somebody about mediation and encourage them to use those skills, use mediation as a form of resolving your disputes going forward. So spread the word, basically. Thank you.
Thank you, Ms. Maloney. And now we have our last panelist, Ms. Rennie Batiste, joining us from St. Vincent.
Good morning, everyone, and thank you so much for having me today. I thank Ms. Maloney for helping me this morning. I had an unusual challenge, you won't believe it, but thank you so much. And indeed, I'm grateful to the ministry for this invitation so that I can make my presentation today. Forgive me, I'm not a techie person, so I'll be doing it the old-fashioned way. And having had my eyes on the screen, looking at all those beautiful pictures, you have my face. So here we are. For me, looking at it as a Caribbean experience, and Ms. Maloney and I, we have worked together on a committee. I was appointed as representative of the Bar Association on the Mediation Committee and became very active in the Mediation Committee of our High Court. It is designated as the St. Vincent and the Grenadines National Mediation Committee. I will take you through this for the purposes of understanding the environment in which we work. The Mediation Committee is established in relation to the practice direction you would have heard Ms. Maloney made reference to. On this committee are representatives from trade unions, the Ministry of Legal Affairs, religious bodies, the Chamber of Commerce, the Employers Federation, somebody from the Attorney General's chambers. The registrar is there. She should be and act in the position of secretary, but the court-appointed mediation coordinator is the secretary of our committee in St. Vincent. Working on this committee, the powers of the committee is to monitor what is happening with the mediation, the court-connected mediation, how we can bring more awareness to the general public about mediation, also assist in seeing if we can get more persons trained, lawyers and non-lawyers as mediators, assist also in the recommendation for the appointment of court-appointed mediators. For example, if a lawyer who's done the training applied to become a court-appointed mediator, I would have to excuse myself from the panel during the time the deliberations are taking place, because I'm a lawyer, so I should not be there when the trade unions and everybody else is discussing the results of this application. We try to roll out public education programs, and what we have done in St. Vincent is to host a mediation week, and we've had 2 successful ones so far. In the public education sphere, we had a pop-up pro bono clinic outside one of the telephone companies. So everybody has to go and pay their phone bills. So we use that opportunity to engage with the general public. Also, we've had one during Law Week at the old library grounds so that the general public, this sits right in the thoroughfare in the city, so general public can also engage with us, and outside the premises of a concert hall, well-known concert hall, so we can get the general public, and it's near to a bus terminal, bus station, so that we can engage. So that's how we try to engage the public. Other than that, we go to communities, north and south of the island, or we also go to the Grenadines. As you know, St. Vincent has 32 islands and keys, and we go to the largest Grenadine island and do a pro bono session and a public awareness session under the almond tree, where it's the most famous gathering spot for the general public. And sometimes we do it in a school or classroom. One of our venues has been the churches. During the church services, either on a Saturday night for the Catholics or Sunday morning for the rest of the Anglicans, the Methodists, for the Seventh-day Adventists, it has been done on the Saturday afternoon, so that we can bring mediation to the general public. So that is the outreach to the general public. Now, for lawyers, we would have had in the original uptake of the Declaration of Court-Connected Mediation, we had what is known as 15, I think, lawyers attended, and 5 non-lawyers attended the original training. We had a subsequent training and that was in 2005, 2006, and in 2018, we also had a second cohort of persons being trained. We maintain a list, and I've asked the registrar to continue to publish the list and put it at the courtroom so that persons can have an idea of who are the individuals who are court-appointed mediators. Now, to understand our process, Ms. Maloney explained some of it. We have court-appointed mediators. Everybody will do the same course, which is done, get a certificate, I think is from St. Augustine campus, the trainers, it's the University of West Indies, St. Augustine campus, and the Judicial Education Institute certify us 40 hours. Do a wonderful program. The non-lawyers are drawn mostly from teachers, retired teachers, current teachers, a couple of persons who were social workers, and a number from like the National Insurance Services and persons involved in property management and accountants. Those have been the persons so far who have been trained as mediators. What we have discovered, as Ms. Maloney would explain to you, as one of the challenges is that persons still believe in our jurisdiction that the best thing for justice and access to justice is to go to court, have your day in court, and fight it out in court. We are trying to disabuse them of that adversarial aspect of our judicial system and get them to understand that we can come together during, either before or during the court hearings. What the feedback we have had is that even though some practitioners will try to instill that in the litigants are still of the view, my best thing is to have my day in court. For those of us who have a background in dealing with community service and having done community service, and we are in the legal profession, we still try to disabuse litigants that the only place to do this is in the courtroom where the adversarial system exists, that the court has provided this avenue for mediation, for us to sit down and discuss the issues, that there's a neutral third party. All of this you're required to tell your client. However, some of the feedback is that there are, when you have been groomed in an adversarial system, it is a difficult shift. It's a paradigm shift that has to be made for persons to allow their clients the opportunity to sit and discuss. So in going to the schools, what we do sometimes a mock mediation, and the 6th formers, 5th formers, we take them from secondary schools into college. And they are surprised that this situation even exists where you can sit even though the matter is in court. So that we thought that that's one of the grounds to get people groomed into mediation to understand that process. The second part of the program in St. Vincent is that the Jurist Project and Impact for Justice, they held a program of training for community mediators. not too many community mediators have been trained. However, they solicited support and experience through the teachers and some persons in business to work as community mediators. And my feedback from a couple of the lawyers who have been trained as community mediators is that some of the land cases that they have had have come to a solution that the parties themselves didn't understand why a case would take 5 years to come to be settled. And it could have been settled in 5 weeks. That has had a certain measure of success, but our success continues to be limited. Even though it is mediation and community mediation, which we explained is aimed at helping, it's another avenue to justice. There's still the diet that my only justice is either retribution or the court make you pay and I get revenge. So in our experience, we have to try to break that line of knowledge that you're not going to court to get revenge or the court is going to act to give retribution. But it's to try to bring the parties together, restore relationships if possible. And few of the persons in our feedback have indicated, oh yes, this can work. Where we have seen, however, of late, as a community person, what I've observed is an upsurge of anger at sporting events, where there's this level of disrespect and ill discipline towards the referees. And the sporting organizations now have to themselves go into their constitution to see how the disciplinary provisions are, and if those disciplinary provisions, in fact, assist them. So then in looking at this, I was very fortunate in having an associate who was a lecturer at the Faculty of Law in Barbados at Cave Hill. He'd written a sports book along with a Trinidadian Caribbean sports law, and encouraged them to come to St. Vincent and to work with the CANO, which is the Caribbean Organization for National Olympic Committees, to work with them from that level to get them to understand in sports what is possible, because Dr. Jason Haynes, I can name him, he's trained as an arbitrator as well. And so he has been they discuss those issues with some of the parties. So in St. Vincent, that has been our experience. Yes, we try the pro bono aspects because quite a number of the persons who come to court are not able to pay fees. Another set, the court, we have been fortunate in being able to do assessments because it's a small country to do assessments. And we are indeed grateful that a new avenue is coming up for mediation in criminal matters, which the Chief Justice will speak more about to our entire constituency in the Eastern Caribbean. Thank you so much for the opportunity to share with you on these aspects relating to mediation, a Caribbean perspectives in Vincent and the Grenadines case. Thank you.
Thank you so much, Ms. Maloney. Oh, sorry, Ms. Batiste. Sorry about that. Thank you so much, Ms. Batiste. And thank you for joining us. We know it was tight this morning, but I really learned. And I liked how you said we have to change the perspective of the participants from adversarial and their understanding of justice from adversarial, and that is really a major challenge that persons face. I think across the board, when we think about mediation, they want their day in court. They want revenge. So I'd now like to invite all of our panelists back onto the screen, as well as my co-host, Justice Kokoram. Okay, so we have everyone coming back on. So we have a challenge with Mrs. Emmanuel. However, hopefully she'll be able to join us again. She's having some technical difficulties, as we know, we have become accustomed to with this particular mode of meeting, right? So Justice Kokoram, can I hear some thoughts from what you would have heard from our panelists.
No, this was an excellent exhibition of thoughts around the Caribbean, snapshots, little snippets of their wisdom of how the mediation idea and philosophy is unfolding in the Caribbean. And you can see a synergy across with regard to our challenges and the innovative solutions. I thought there are a couple of things from each of the presenters that struck me. Beverly, of course, I think back in 2010, when we had our mediation symposium, she was the champion of transformative mediation at the community level. And that's something that always struck with me as in terms of the potential of mediation. I like her contribution about supercharging the transformative benefits. I think that's something that we could take into the room. I love that word about looking at how we can now take the mediation product to the next level, pinpointing areas of conflict in our society. I don't know whether we've done a study in the Caribbean of the stresses in our society that creates conflict. And I think that's of benefit for ministries as well as for the judiciary. What are the stresses? And what are some of the indigenous structures that could help? I thought that was a valuable perspective. John, of course, I mentioned in the chat, the Jamaican model is the leader in the Caribbean on automatic referrals. They were the first one to kind of dress up and make it sound nice about mandatory mediation. It's not mandatory. We're taking the horse to water, John, but I'm just waiting for the other jurisdictions, my jurisdiction, to follow suit, to trump and follow suit, as we say. So there's so much we could learn from Jamaica. And John is right. Mediation is a game changer. And from the wealth of experience from Jamaica and the DRF, I mean, they've been spreading the message to Africa and other jurisdictions. And there's a lot that we could learn from taking mediation to the next level, introducing it in our even political discourse. I think John's colleague, if you Donna Parchment, is, and maybe he can chat about that. Rennie, before I get to Rennie, Maloney, there's something that struck me over Maloney's presentation. I had it here. Oh, the lawyer and the client in the mediation room. That is a huge, when we talk about game changer, John mentioned the whole question of getting the client to empower themselves and also getting the lawyer to transform themselves to be part of the mediation process. That we're still facing that challenge, Deborah, and I really appreciate how you've tried to deal with it in your jurisdiction. It's not easy, but it calls for an education campaign, right? It's a money question at the end of the day, and we just still need to keep sending that message that you can benefit. Lawyers can benefit if your clients are happy. And I think that's something that John as well appreciates in Jamaica. So thank you very much for that, Deborah. And of course, Rennie, I love the testimonial. And I think, was it Rennie you mentioned about the almond tree and the mediation week? There are things, we talk about stressors in society. There are actually blooms in our society that symbolizes peace as well. And the almond tree is not insignificant. And I think in Trinidad as well, I think Beverly could remember we were looking for a tree in Central, where we heard that the communities used to gather below. And I for the panchayat, I'm not too sure if it was a silk cotton or a banyan, I can't remember, but symbols of peace, I think, is very important, Rennie. I grabbed onto that. I would love to hear more about the pro bono clinics and the mechanics of how it's actually done, the lead up to it. I think Beverly as well and Deborah may be doing that kind of work, and John in Jamaica. But it's interesting. How is that done? There must be a lead time, an advertisement, getting the clients to do it so that on the spot, the mediation can be conducted. But those are just my thoughts, Rennie, on this eclectic display of a wonderful mediation experience in the Caribbean. Thank you for everyone. Thank you very much.
Thank you. Yes, it was really, really rich presentations from all of our panelists. And we would have had some persons putting some questions in the chat, but I also want to hear from, and some of you all would have touched on it, the challenges. Well, Ms. Maloney, you definitely touched on them, but I want to find out from all of you, though, what is the major challenge that would stand out to you in getting the public in particular to accept mediation? Because we know professionals, once it is they hear about mediation, they train in mediation, of course, it becomes a part of your life. But the public, what is one of the major challenges that stand out to you personally about getting the public to accept mediation?
Would you like me to say?
Oh, sorry. Senior, you can go ahead.
No, I yield to you, Renee, please. I'll speak after.
Okay. Now, I think might be a peculiar case in that I have been a political figure. I continue to be a political figure. Okay, so when I have my clients and the judge indicates this is a good case for mediation, and I say, yes, we agree, the lawyers agree. On the list of mediators, because the SLS is a small country, the client on the opposite side would select a mediator they know is my political opposite. Okay? And I can see on her face, because these are not sophisticated people most of the time, I'm going to do for you because you're on the opposite side. And then I will smile and say, oh, that's great. I'm glad that such and such counsel would be the mediator in this matter. And then they go in a shock mode because that's not what they're expecting. They're looking for a different type of response. When the mediation now takes place, I explain to my client, I will not be sitting there. This is your opportunity, because we went through the matters before. This is your opportunity with a figure who is the mediator for you to sit down and discuss. And the first thing they say to me, well, you and she not in the same political party. I said, that doesn't matter. You listen, and if you feel uncomfortable, you let me know. But I could see the surprise on their faces always, because the judge we put 3 names. And I can see the litigant immediately would choose that person who because we're on the political opposite, would expect me to have a different outlook, and all I will do is smile, because we are professionals. And as professionals, we must show that face to the litigants so they can have a better belief and understanding of the process of mediation. And it does take some time for them to see, oh, she's not doing the law according to her political affiliation. And then when they sit with the mediator and they're going through the process, they then after say, but Miss B, I didn't expect that, the 2 years I thought out, we couldn't get along. So you have to be a professional in outlining what you're doing with your clients and help them along to understand the process of mediation, because they have lots of things in their heads that you have to disabuse them of, and the reason for the process of mediation. Thank you.
Oh, thank you so much. That is a really good testimony. And I really appreciate as well, because you wear different hats. And it is important to allow the clients to see that even in wearing those different hats, you are able to separate yourself and give them the best possible service.
One of the, if I may.
Yes, you may, but can you speak a little bit louder?
Are you hearing me now?
Yes.
Okay, good. All right. One of the main issues in Jamaica, and I dare say around the Caribbean, is access to justice. Persons, whilst you can get a mediation in Supreme Court, there is a cost to it. And it's roughly $25,000 per party, which is Jamaican dollars, by the way, Jamaican dollars, which really equates to roughly 150 US, thereabouts, right? However, the majority of the cases are in the lower courts, the magistrate courts, the parish courts, and what have you. So that's where you find the bulk of persons with issues. And of course, affordability is an issue there too. So you have parties going to court in the parish courts and what have you, and really can ill afford the bus fare to get to courts. I am pleased to say, though, in Jamaica, what we have now through the government of Jamaica, and I must admit, the ministries of justice and national security over the years that I've been involved, right, successive governments or what have you, have always supported dispute resolution mechanisms. But now, if you go to a parish court and you want a mediation, carefully, listen to me carefully, and you want a mediation, you will get a mediation. If you can't afford it, the government will pay for it. So we now have that issue where parties go to court and we have persons there. If you want a mediation, you can't afford a mediation, the government will pay for it, which is a great thing. So we're constantly at that level, not only encouraging mediation, but persons are getting to realize there's access to justice in an affordable fashion. And I think that's a major game changer at that level for us, and it permeates through society. You know, people saying, I want a meditation. No, it's mediation. And you'll get a mediation, right? So we have DRF personnel roaming the courts with their badges and what have you, and if they want it, we'll sort it out for you. So that's one of the things that I found was an issue, affordability, but I think we've broken the back of that in a certain way. Okay, thank you.
May I go ahead, Ms. Williams?
Yes, you may.
Okay, thank you. I think that's wonderful, wonderful, John, and we still have to have our meeting, definitely. When Ms. Batiste spoke, what came to mind was the whole notion of carefront conflict, so that her approach in the circumstances in the court would have shocked the other side, because nobody has this notion, which is the first time I'm hearing it, and I'm definitely going to steal it, whoever came up with it, of carefronting conflict. So I love that. For me, what I would say is it's twofold. Both the legal practitioners and also the public education, they go hand in hand. And the reason I say that is because if the average man really knows and understands what mediation is all about, then he or she can exercise, the right to go and say to the court, I would like my matter to be heard at mediation. And they are not misguided, so to speak, by a legal practitioner who may think that this is going to take away from my purse. So both the role of the legal practitioner in mediation and also the need for that public education to be widespread and ongoing, those are the two main issues I see for us. Thank you.
Thank you very much to you all. Justice Kokram, is there any questions that you would like to ask the panel?
Well, I'm picking up some very interesting observations in the chat, and I just picked up two. One from Eartha White and Emily Beecham, and let me float it to the room. Eartha is saying our culture is not one that emphasizes conflict resolution. And so what's your thoughts on that? Is our culture confrontational? That's an interesting thought. I have my own thoughts on that. I think it's a sort of the dog wagging the tail. Is it that our society is inherently confrontational, or is it just reflective of the leaders in our society and how they deal with conflict? So is there some sort of synergy between those persons who should be leading, teaching us the wrong ways of dealing with conflict that is leading to us becoming an angry society? So that's one question. The second one from Emily is that the public needs to be informed of the success of mediation. So your views on educating the public on the success of mediation. Those are some very interesting questions there.
Yes, and I think
any takers?
Ms. Maloney would have talked about that in her presentation as well, in terms of evaluation of the process and sharing statistics. So yes, that is a really good question, Emily. I'm seeing some responses as well.
But does anyone in the panel have a thought on the chicken and egg situation? Are we inherently confrontational, or is that learned behavior?
I try to say a few words on that. I honestly believe that as a people, and you said it earlier on, Rash, as a people, we are not inherently violent or anything like that. We're very loving people. We're a loving set of people. The beauty of the Caribbean is in the people. And that's it, not just the beaches and the food and the music, it is the people that do it. So I honestly believe that it is not something that we have to unlearn violent behavior, anything like that. We need to embrace what we do best. And those of us who have gone down the wrong path, treat them with love, bring them back into the fold. And then I think positively will permeate through society, whereby that cultural change I'm looking for, that cultural change, that I believe was learned, right? That cultural change will fall back into line, whereby we are able to get back on track. And we're not too far off of it now, as we can see from this wonderful panel and this wonderful conference here this morning.
Thank you. I think I want to remind us, the words we use when we start building awareness about things. We use these words: the fight against poverty, the fight against, and you have no idea of what the subconscious is doing. And now we're beginning to understand this when we see what's happening with AI, with TikTok, and so on, how the algorithms that they use to figure out what to feed you. We have been subconsciously sometimes, as a politician, say, I'm going to go there and fight for you. I'm going to fight for your right. And we forget, it's the language and those subliminal messages.
That is so true, but really, that's so true. There's one controversial fight motto that we used recently: the fight against COVID. And what we do with COVID, we live it with COVID.
But you see, sometimes we're not even aware, as we, when I was reading about these algorithms, how these things work.
No, you're right.
It's now that we're beginning having this avenue, we're beginning to understand. For example, as a politician, when I used to have my clinics, and if one person saw somebody from the other side coming to me, it's like a warfare, and I have to tell them, no, you're all Vincentians here, calm down. And you have to, as a leader in the community, be you a parish priest, a lawyer, or whoever, you have to also have that responsibility and latch on to the national agenda. So the national agenda also needs to come, not just from the lawyers or from the court itself. It's the leaders also have to buy in very strongly into this process of how do we restore justice and community justice. Don't just leave it to the court, because that's the court's business. Don't just leave it to social development, because that's community development business. We also have to try and get the other leaders who are quite persuasive to also join into this process that we're trying to build, this conciliation and this restoration of justice.
If I may add my 2 cents to that, I do believe that there are those who hold the belief that I am entitled to, I must have my day in court. And because of that mindset, mediation and any type of ADR is not at all appreciated or valued. And in fact, it's not seen as beneficial. So I support that idea of the success stories. So not just educating them, but showing how it has been successful. Let the record show this has worked, and in various types of cases. So I love that idea of tagging on the success stories to the public awareness campaign. So that's something we're going to take on board for the Eastern Caribbean. Thank you.
I also think, just to add another piece to the puzzle, that we attack at all different levels of society. In the schools, they talk about peer mediation, they talk about mediating. We're talking about in terms of the communities where we have conflict resolution, where you have community centers where they're taught, and of course, the courts we spoke about, and in trade. Now we're seeing on a global stage, countries and also major companies are seeking to mediate first, even before arbitration. The other day, $1 billion US settlement was mediated between India and I believe it was Singapore, right? And Lim did it, George Lim, a friend of mine, did it. So we're now seeing where parties are actually saying, look, let's not even arbitrate. Let's see if we can mediate, sit down, get a third party neutral in here, saving cost, energy, time, and affecting the bottom line of their profits. So if we can affect that cultural change locally and regionally, we're onto something. Thank you.
Thank you very much. And I really appreciate.
I just have one sentence to say, which is just to
Okay.
reemphasize that point of what Rennie and Deborah and John are saying about culture shift. And,
Mhm.
and the legal system has to take a major part on their shoulders. The only recognized system of dispute resolution is in our courts, which promotes a combative adversarial approach. So if that is our process, as Rennie and Deborah and John, it filters down into our society. If we transform the judiciary into a peace center, into a different way of thinking of approaching it with disputes, that's where we talk about, I think Beverly used the word, supercharging the transformation of mediation, the next level, So the judiciary has some introspection to do as well.
Yes. And I also liked that Ms. Batiste sort of talked about the national agenda. It has to be across the board in all societal structures, led both from the top down and from the bottom up, because we have to get it in our minds that there must be a shift, and to say a cultural shift, but a transformation of our minds at every level in order to get the word of mediation across. So we would like to thank our panelists, but they are not leaving you yet. We really hope that all of you can join our breakout rooms, as would have been indicated at the beginning. We are going into our breakout rooms and we want to hear from you. What are the perspectives, the solutions that we can put in place to get the word of mediation out to our different regions, out to the public, out to our lawyers, get a transformative approach going in our society. So we would have, you would see on your screen coming up, we have 4 breakout rooms. You will each be put into a breakout room. In the breakout room, you will have each of our panelists. We would also have one of our staff members, as well as one of our rapporteurs. So please, we want it to be an engaging breakout room, be able to use the chat as well as your voice. You'll be able to unmute your mic in the breakout room. So you want to be able to use your chat and your voice in the breakout rooms. So as I indicated, we have 4 breakout rooms for our 4 panelists. Yes. So you would see the prompt to join a breakout room coming up in a few seconds. I am hoping, yes. Right. So it will come up in a few seconds. And we also want to encourage you to give feedback to our facilitators in the chat. You can also ask questions in the chat as well. Right, so we will see if we can take some of those questions when we come back from the breakout room after we have gotten feedback from each of the breakout rooms. We do again apologize. We were having some technical difficulties earlier with our panelists, one of our panelists, but we do have Mrs. Harry Emmanuel back with us, and she will be in one of the breakout rooms as well. So we invite you to click join now for the breakout rooms and go into the breakout rooms. So I see persons are joining the breakout rooms. And we have persons, we are down to 60. You can join the breakout rooms at this time. We just have about a few persons again who have not yet joined the breakout room. If you are unable to join a breakout room, you can still stay in the plenary room. However, we want, if you can, please join a breakout room and listen to the discussion. Even if it is you are unable to unmute, you can use your chat to join the breakout room.
Hi, Renee?
Yes.
I'm seeing room 1 for me, and I should be room 3, I understand.
Okay, so we will have Miss Frances move you to room 3, to the appropriate room, sorry, at this time. Miss Frances, are you able to do so? Okay. All right, good. All right, so I'm seeing persons in the appropriate breakout rooms. Again, making a last call. If it is you're unable to move to your breakout room, contribute in the breakout room, that is fine. We appreciate that if you can use the chat, or if it is you are able to just listen to the conversation, but you can move to accept the breakout room now. So I'm seeing some feedback in the chat.
Miss Batiste, can you hear me?
I can hear you.
Okay, great. So whenever you are ready, we can proceed.
Yes, we are supposed to end the breakout. What steps can be taken to raise awareness about the benefits of mediation as a conflict resolution option? Huh?
Yes.
But
Just to assist the group, we have 4 questions that we would be discussing in this group, and then a presentation. Well, we would present the ideas that are discussed in the group to the main forum, right?
Yes.
I would have been volunteered to do the presentation on the information that we would discuss, so we can discuss and present the information with ease.
So, what steps?
And would you like me to read the question?
Please.
Okay.
Yes, please.
Right. So the first, I can read all the questions and then we can go into the questions individually. So we are looking at what steps can be taken to raise awareness about the benefits of mediation as a conflict resolution option. That's the first question. The second one is, in what ways can organizations promote mediation as the first option for conflict resolution to their employees? Next, other than financial, what incentives can be provided to encourage parties in dispute to consider mediation as the first option for conflict resolution? And the fourth question is, what are some of the challenges and obstacles that need to be overcome to make mediation the first option for conflict resolution? Right, so the first questions we are looking at, what steps can be taken to raise awareness about the benefits of mediation as a conflict resolution option.
We could hear
Ms.
from
Nadeem?
our participants.
Can I speak, Jared Diaz?
Sure.
Okay. Hi, Olivia.
Hi. Hi, Mr. Diaz. Hi.
How are you doing?
Good, thank you.
All right. One of the things I heard in the presentation was this thing of like best practices kind of thing.
Mhm.
I remember, well, we actually did at the ILO. I worked at the ILO with Miss Harry Emmanuel, and we were involved in a program called Trust Building in terms of management labor cooperation. And actually, that was a key element in pushing for trust building between management and labor in the region, which was to highlight best practice examples of where trade unions and management cooperated and change the conflict situation that they were experiencing to a situation where they cooperated. So it was held at the Hilton, and each parties explained what they did, what they did to build trust and all of that, and explained each from the different countries in the Caribbean. And so as I heard that there in terms of mediation, that you could do it is a more micro level, but the same thing could be done. And what was done also too is that what the parties presented at the conference was taped and recorded, and then was used in a program which we went out to the different islands of the Caribbean, and with the different unions and employer organizations and all that, we did a program on trust building using those videos of what was the best practices in terms of trust building to further that whole management labor cooperation. So it's actually, if you could have examples of situations where mediation changed the relationship or solved a problem or whatever it was, and people were able to present their experience, that could well be one of the ways in terms of promoting a positive image and outlook on mediation. So people would see live examples of how mediation transforms situation. So I just, right? So that's one thing I would suggest.
All right. Thank you. Mr. Diaz, before you go, one question. Can you give us an example of one of the trust building activities that would have been taped and shown?
Well, you had I think it was a long time ago. That's 2000. That's before 2000. But let me see. I think there was the containerization. I think it was Jamaica, where they were moving from break bulk cargo to containerization. And if you know, like in our port, if you remember long ago, the Seamen and Waterfront Workers Union used to be a huge union, and it had endless big burly stevedores and all that. They would actually empty the ship, break up the cargo physically, manually. You had to be a big fella to work in that industry. And the union was huge, with in terms of membership. But when they moved from break bulk cargo, when you no longer needed to break it down, but it was containerized now. So they just use cranes to take it off the ship and put it on the docks and all that thing. It changed the whole work situation and all that. And of course, with a major change like that, you will have attendant stresses and the opportunity for a lot of conflict between the labor representative and the employer representative. So I believe that that company explained how they worked through that situation, and how they were able to, of course, trust is the basis of all these things, how they were able to move from that situation they had before to a new situation without like major strikes and shutdowns and that kind of thing. You know, so that was one that I vaguely remember.
All right, thank you, Mr. Diaz. Ms. Batiste?
I see there are two hands up.
Yeah.
Karen, let's take the two hands then.
Karen or?
Yes,
Okay.
Karen, may I speak? Right, so building on Jared's point of what is essentially stakeholder engagement and building trust, a natural follow-on I see to this is that you build in the process of mediation as part of the grievance procedure in companies, because most often if you have negotiated collective labor agreements, even just company manuals where unions may not be present, and you have a grievance procedure, that you build in mediation, and that becomes mandatory, I suppose, in one sense, to promote its use and its value in changing relationships and preserving relationships. So that's what I wanted to add. Thank you. And I posted a comment in the chat about churches playing a role where their congregations are concerned about promoting what mediation is all about to that stakeholder, because they're all stakeholders too in community. Thank you.
Thank you.
Okay, and Kai. And
Hi, good morning. I'm Kaya, or Paula Maria Fortune, as some of you know me as. I want to endorse the fact that Jared spoke about trust, but I think it was Emmanuel, she spoke to the trust, respect, confidence, and authority. And those, I think, those four pillars underpin the manner in which persons will accept or not accept the mediation. So even in terms, so Jared spoke about trust, and if you want to look at the confidence levels, it needs to be like a media blitz, in my respectful view, in terms of having the persons within the communities know this is available, it is affordable, there are systems in place for it. But if we remain quiet as mediators, if there is only a pop-up, now and again with respect to mediation, and people are still confusing it with meditation. I mean, it becomes a difficult environment for us to function in as mediators, in addition to which training of the participants, teaching the participants. So from the trust building, the confidence building comes the training or the teaching. And I had put up something in the chat earlier with respect to training legal practitioners. So I'm speaking from a legal perspective. Training the legal officers, because at the law school, there was a very intensive program of mediation advocacy being taught to the legal practitioners. And you can see it's chalk and cheese difference with attorneys who have had the training in mediation. They are more willing to accept the process than attorneys who haven't been trained and are still suspicious of the process. Yeah, so I mean, I could go on, but I will leave this to other people who have their hands raised.
Thank you, Kaya.
Yeah. Thank you.
Good morning. It's Gregory Privat. And I just want to highlight some things that were done in my experience with in the employment industry, right? In Trinma, right? And it's through Trinma, I did my mediation training. But what Trinma did, and then Petrotrin on a wider scale, they sent employees, whether it was from HR, IR, or union officers, to mediation training. So a lot of mediation training in Trinma was trained, and we actually formed a committee comprised of the stakeholders, union, and management, right? And that committee, we decided to, as part of the dispute resolution process, we're going to use mediation. So we met not as part of the grievance procedure, but as part of the dispute resolution process. And it's had time we practically did, we did a lot of co-mediation. And in those co-mediation, it might have a union person and a company person, right? But it wasn't identified, we would just identify as mediators in that scenario. You take off your union hat, company take off the company hat. And we met with the disputants, and sometimes it might have been a company issue, or sometimes it could have been a worker issue, right? Could be worker peers, or could be management and lower level worker, right? A lot of those mediation were successful. A lot of those mediation prevented the matter to going further in the grievance procedure. But essentially what it did was to give the parties, the disputants, a clearer understanding as to the dispute that they were facing. Mm-hmm. And it gave a little confidence, right? It built the confidence in the mediation process, right? So, well, to be frank, I was really kind of disappointed in that in the Petrotrin scenario. At the high management level, they weren't able to engage in mediation to discuss some of the major issues that led to the closure of the company. But mediation was it was actually launched, and Justice Kokaram was present when Petrotrin launched the mediation. They officially launched the mediation committee, if you want to call it that.
All right, so Mr. Privat,
Yes.
I have to stop you at this time because I'm being told that we have to finish at 11:10.
Yeah, no problem.
Right?
No problem. I just wanted to bring that to the table.
No problem. And we have a couple more questions, Ms. Batiste. Ms. Batiste, your microphone is muted.
Yes, so far we haven't had, we've had organizations. How do you promote the first option for conflict resolution? But the raising of public awareness, we needed some input there, some suggestions there, and one of the incentives.
Okay.
Some input from persons in those two areas.
All right. And that's just the first question.
We have two hands up, so maybe we take the two hands, perhaps they can zero in on those two areas if possible.
Hello?
Yes, you can go ahead.
Okay. Yes, good morning and thank you very much. I just want to commend Ms. Batiste. I truly enjoyed her presentation.
Bernice, if we can focus on answering the question that is put to the group, please.
Oh, okay.
Because we have a limited time and we have a couple more questions to get to.
Oh, because I had my own question. I just wanted to zero.
No, this is not the forum for that. We are discussing in this group particular questions. So we're going out to present information that we would have discussed in the group, giving options to the forum, right? So
well, I'm going to reserve. I'm going to just reserve what I'm going to say then. Yeah, I'll let somebody else speak.
All right. Thank you very much.
Yes, you're welcome.
Rebecca Beckles.
Hi, good morning. So one of the things I was thinking of is I know sometimes they have these little skits on TV where they highlight different services. So that is one way I think that it can be broadcast to the public. And also in schools, when we as guidance officers do the conflict resolution sessions, mediation is one that I definitely think that we could include as a way to settle disputes.
All right, thank you. Ms. Batiste, would you like me to read what's in the chat? Okay.
Yes, please.
Okay, thank you. So there is, how can we engage churches so mediation can be incorporated into policies and procedures of various organizations? And various organizations can use EAPs, etc., that handle mediation. Someone said, Ms. Batiste, I love the idea how you reach out to the religious organizations to get the messages out, because that will definitely meet a large group of individuals of a certain status or affiliation. Right? Someone also, mentioned again, churches can play a role.
They do.
So we are supposed to wrap up the discussion. We are supposed to be wrapping up and we are still on question 1, right? So we have mediation committees, schools, peer mediation, public service announcement, public skits, police service. Okay, so the second question, is, in what ways can organizations promote mediation as the first option for conflict resolution to their employees? Yes, I'll type it in the chat. Ms. Batiste?
Yes, I think I see here, remember our first trade union rep spoke about trust building exercises, making it part of the grievance procedure for employees, and to send employees for mediation training in dispute resolution process. I have those 3 points taken from the speakers before. What organizations to promote mediation as the first option of conflict resolution. So if we can—
Sorry, Ms. Batiste, can you repeat it so I can write it down for number 2?
This one is, what ways can organizations promote mediation?
Yes, as the first option.
Trust building exercises, making it part of the grievance procedure of employees, and send employees for mediation training in the dispute resolution process. Those are the 3 proposals that came out so far.
Okay.
And the steps taken to raise awareness about the benefits for conflict resolution, reaching out to churches, skits for television, include in schools for conflict resolution, mediation committees, and have that, and public service announcements.
Okay.
And the other question was, other than financial, what incentives can be provided to encourage parties to use disputes to consider mediation as a first option? So you're looking at incentives now.
Yes. We have 45 seconds remaining.
What incentives?
Anyone would like to share any incentives that can be used to encourage parties in dispute to consider mediation as the first option?
I think one thing coming from the conversation is not having to pay, because I think a lot of people who are not who in the legal process already don't want to have another bill to pay to go to a mediation and then still pay for lawyer and things. So
right. So the first was other than financial. Rebecca, I think I saw your hand up.
Okay. Welcome back, everyone, to our main room. I know you would have had an avid discussion, and I know some of you were giving really excellent feedback. All right, everyone is back in with us. Excellent. Also, Justice Program, I am excited to hear the feedback from our rooms. We some questions that were posed in the rooms, and I know persons who are professionals and even the public were excited to hear from our experts across the region here today.
Yes, so let's open the floor for the first group, which was being chaired by Miss Beverly Harry Emmanuel, and then we follow with Miss Batiste's group and Mr. Bassi's, and then finally Miss Maloney.
Okay. I think Ms. Stewart is presenting on behalf of Mrs. Emmanuel's group.
There you go.
Thank you, Ms. Williams. Of course, there never is enough time in these breakout rooms to fully ventilate the questions, but we did have an opportunity to have a short discussion on at least 3 of them. The first question was, have you ever used mediation, or do you know someone who did? In your opinion, what were the benefits derived from that experience? So the conversation suggested that not many people would have had the experience with mediation themselves directly, but based on what has been heard about from persons who have participated in the process, the outcome is usually one that is satisfactory to participants. It allows participants to have the opportunity for skill building. And when you have that opportunity to sit in front of another person and discuss the issues, you hear from them what are the real issues coming out of the dispute, and in that way you're better able to work towards a solution. We even had one participant sharing that in her community, through the temple, they do have a project where they use mediation, and it really is about raising public awareness, right? And educating the community so that they could use this as a first means in conflict resolution. Moving on to the second question, what role can the media play in promoting mediation as the first option for conflict resolution? One person suggested that the media, usually when you hear about conflicts in the public domain, the media usually focuses on the pre-action protocol letters as well as engaging lawyers to assist them in dealing with conflict, right? But the media can play a vital role in terms of sharing more about conflict resolution, utilizing mediation rather than taking the adversarial approach, which in most instances may not necessarily be beneficial to the parties. And it is really about changing the attitude of persons as well when it comes to considering mediation as a first option. Question number 3. How can cultural and societal attitudes towards conflict resolution be changed to make mediation more widely accepted and embraced? So one person in our conversation would have suggested that persons have the attitude where they want to win. They want to be strong. They don't want to be embarrassed, especially in conflict situations, right? So it really is about raising more public awareness and education and changing the attitudes of the persons towards how they deal with conflict. And as Ms. Emmanuel would have challenged us earlier on in the conversation through the panel discussion that we can also try not to just think of mediation and conflict resolution skills when we are faced with a conflict or in a mediation session, but try to apply those skills as part of our life. And that would really assist in changing cultural and societal attitudes towards the approach in conflict resolution. We didn't quite get to the last question, but just for information so that persons could further think and deliberate on it. Question 4 would have been, what are some of the challenges and obstacles that need to be overcome to make mediation the first option for conflict resolution? Thank you.
Thank you very much, Ms. Stewart. So we will go on to room 2. Can we get feedback from room 2, please? That is with Ms. Batiste. And I believe we have Ms. Olivia Smith-Shaw. Yes, thank you.
Yes, so of the 4 questions, we got to 2. The first question was, what steps can be taken to raise awareness about the benefits of mediation as a conflict resolution option, right? So some of the suggestions and feedback coming out from the group were, there can be skits that can be highlighted. There are different programs aired on TV utilizing skits, which is very engaging. Persons respond well to them. So this can be used as an information tool as well for persons to be made aware of what mediation is. Utilizing our churches and in different aspects that would include your mosques, your temples, utilizing areas, places of worship, places where persons trust, already established an area of trust, right? So utilizing those areas can be used, right? There's also television, the use of television, which would have been touched on in terms of media. The schools, so the peer mediation program was introduced in this discussion where persons were talking about informing young persons at a tender age, right? And of course, we are aware, we would have been made aware that if young persons know about conflict resolution from a very young age, it can change and impact our society in a positive way, right? So public service communication, so reaching out in different forms to inform persons of mediation, so giving persons that information, raising that awareness would allow persons to see and be informed so that they can then utilize mediation as a first option to conflict resolution, right? The second question was, in what ways can organizations promote mediation as the first option for conflict resolution to their employees? So our group, we had the benefits of having someone who would have been in labor and would have had that practical experience to share with us in terms of trust building. So building that trust within your organization, building it between management and labor, so you can identify this. So if it may not be labor in your organization, you can relate it to employer, employee in your organization. So building that trust is helpful to promote mediation in the organization. Also making mediation a part of your grievance procedure. Someone would have shared their experience from where they were working, where the employer made it mandatory that they participate, that they try mediation, and it would have worked out. It would have worked out well, right? And of course, sending persons for mediation training so that persons are equipped with the skills prior to a conflict happening, because we would have learned yesterday that conflict is inevitable. It will happen. So prior to a conflict happening, employees are equipped with these skills so that they can adequately and appropriately manage a situation before it escalates. right? So those were the questions we were able to address. Thank you very much, Ms. Williams. Ms. Williams?
Yes, thank you very much, Ms. Smith-Shaw. And next we have room 3, and I believe Mr. Kellen Charles will be presenting the discussion from room 3 with Mr. Bassi. Mr. Charles? Oh. So, Mr. Charles, unfortunately, we are not hearing you at this time. Mr. Charles, I think you will have to increase your volume. We are not hearing you at this time. No, we are still not hearing you at this time. Fortunately, no, there may have been an issue with your device. So if you may want to come out and come back in, we'll see if it can be rectified. But Mr. Bassi, are you able at this time, or maybe a representative from your room?
I think that we would need Mr. Charles or a representative. I gave my input, which was a Jamaican experience, but I think there was some very good ideas that came up, and hopefully the rapporteur caught them. It was a very lively discussion, and I would love to hear what was caught and what was produced.
Okay, understood. Well, maybe we can go to room 4 in the interim while that is rectified. So Miss Maloney would have had Miss Susan Gordon. So Miss Gordon, are you able to now unmute and put on your camera and represent room 4?
Yes, here I am. So the questions for room 4, there were 3 questions. How can governance make mediation more accessible and affordable to the general public? How can mediation be integrated into the legal system to encourage its use as a first option for conflict resolution? And the third question, which we had to really rush, what are some of the challenges and obstacles that need to be overcome to make mediation the first obstacle for conflict resolution? I'm going to take all the suggestions together because there was a fair amount of overlap. So what was one of the points made was the importance of court referrals. It was noted that mediation at the Community Mediation Services Division and the Family Court is free. That in terms of people who wish to choose other options and go to private mediations, there is a roster of mediations at the various agencies, and they can select if they wish to pay for mediation. One of the areas that was really emphasized is the need for more public awareness of education, the need for more advertisements, the use of social media to get the word out, the need for outreach. The point was made that when one goes to the TTPS, it was in fact suggested that the TTPS should have their own mediation unit, but it was pointed out that in fact the TTPS and community mediation are supposed to work hand in hand, and in quite a few instances, referrals are sent to community mediation, but this needs to be done much more frequently. It's not happening in the seamless way that it should. It was another point made was the difficulty of making mediation a career, because so much of the mediations which are done are pro bono, so that this is something which needs to be addressed so that after the expensive training, it is possible to make mediation a full-time career. The option of mediation first, that this is something which needs to be promoted further, and the need to well, we touched on how do you make mediation compulsory, or how, and that is indeed with the court referral system. But this is something that was emphasized, that it does need to be, the mindset needs to be that mediation should be the first option. And it's very important, the need for people to be able to see the results of mediation. They can go to the court database and see the results of court matters so that they can have some confidence in the court system. And in the same way, there needs to be a database where they can see the outcomes of mediation, which would enable people to have more confidence in mediation. I would like to ask Ms. Maloney whether she would wish to add anything.
Oh, thank you so very much. No, I don't. Thank you.
Okay, well, thank you very much, Ms. Williams. That's the presentation from room 4.
Thank you very much, Ms. Gordon. So I don't believe we have Mr. Charles back with us, but I would like to invite someone who was in room 3, possibly to say one of the things that would have stood out to you in room 3. I believe one of the questions that you had in room 3 is, oh, okay, so I do not have all the questions here, right? So
is our rapporteur available?
The rapporteur for room 3, I believe they are. If they can just unmute, rather than putting on their camera, they can unmute only. Or we can just ask someone who was in room 3 to give their feedback of the discussion. Is there anyone who would like to volunteer from room 3? While it is we either wait on Mr. Charles or our rapporteur to just give some points from the discussion. Anyone who was assigned in room 3? I see a hand, Ms. Hills.
Yes.
Yes, go ahead, Ms. Hills. You can go ahead and unmute.
Hello, good morning.
Yes, go ahead,
A
Ms.
lot
Hills.
of discussions were held in room 3, and people were making valid points, a lot of which were raised already. And the one thing we had was Mr. Gassi ensuring that, the gentleman who was the room facilitator, he was ensuring that everyone's views were heard. We also had the importance of a particular, I'm trying to remember the name of the group, but a group that is already working out there. And as everyone indicated, we were the group is really working a lot. However, the importance of the media and the higher powers that we encourage each other to, work and promote mediation as a method of resolving conflict resolution, the first method. And people brought up different lovely points, wonderful points about how they felt the need for, conflict mediation becoming more to the forefront, using things like the media, yes, media and all the other social services that we have and social things that we have, and also ensuring that as whatever profession you're in, you encourage others to mediate first, and things like that were happening in our discussion. That's just a synopsis of it. But he allowed everyone to talk, excellent areas. And we were recognizing the need for the other, what the other persons had said also too. All the panelists were applauded and each presentation, and someone made the point about the Jamaicans being very proactive in ensuring that it's part of it, and how mediation was something that they pay for it to be done, so we should look at that.
Nashroom was also there too. Nashroom may have something to contribute.
All right, thank you, Ms. Hills. Go ahead, Nashroom. You can go ahead and unmute Nashun.
Hi, good morning, everyone.
Morning.
I was part of group 3. The name of the group is Community Peacemakers. We are in South San Fernando. I am also part of that group. St. Hilaire and Merlin Boys, who are very senior attorneys at law and mediators as well. One of a lady, I can't remember her name, but she voiced her concerns. She was very passionate to say her frustrations that she find that, the mediation process in Trinidad and Tobago has been very slow. So she was hoping that this conference will reignite not only just the conversation, but the actions to follow to really see mediation really taking a footing in Trinidad and Tobago, which is so very needed. So the ministry must be thanked for this conference. I made a point regarding question 2, which had to do with mediation, disputes in the workplace. And I was making a point that maybe similar to the EAP that we have in organizations, that the ministry could maybe have a similar body set up to deal specifically with workplace conflicts, and that organizations can have a policy so that when they are onboarding, and it's a discussion that they can carry through the onboarding process, is that they can inform and educate their employees, new ones, as well as, employees that are already in the organization, that this body is there and they don't have to wait for conflicts to escalate, but they can do it maybe during, before, and after conflict. They don't have to wait until, they have to go with the person they are in conflict with, but they can go by themselves to get some sort of guidance as to how they can play a part in de-escalating the conflict. Thank you.
Thank you very much. Such a rich discussion in each of those rooms. I also see in the chat we just have someone would have highlighted education and socialization in helping to promote mediation in each region. So Justice Kokram, what do you think of that rich discussion that we would have had coming out of the rooms? Any feedback from those rooms?
So it's an excellent and a rich contribution. I have actually tried to make a note of all of these contributions. And if I may wrap it up in a bow,
yes,
somewhat like a declaration from this mediation conference in the following manner. Whereas we all gathered here in this mediation conference of the Ministry of Community Development, embracing the importance of carefronting conflict to promote sustainable development, recognizing the need to supercharge transformative mediation to harness the benefits of mediation as a game changer in our societies, understanding the need to make mediation non-combative in our culture and normalize mediation as part of access to justice. We, the participants, have recognized the following. 1, the need to promote mediation as an appropriate means of resolving disputes by identifying real issues, to promote mediation by a number of means, such as utilizing religious groups to promote mediation in their circles and in their areas of influence, using skits and the performing arts, using media and social media, having leaders and persons of influence and higher positions and higher powers to promote mediation as a first method of resolving conflict, integrating mediation in the police service, integrating mediation in our schools and educational system, promoting outreach programs by social groups and NGOs such as the Community Peacemakers, making mediation the first option for resolving conflict in employment, in employee situations, as part of your group.
Okay, so Justice, by accident you were muted.
Yes.
So after workplace policy.
Yes, onboarding.
Mm-hmm.
Ensuring that there's a database to see the outcomes of mediation, to build confidence in mediation. And finally, seeing mediation as a career and building mediation as a profession. I think those are the things that I've picked up on. I may have omitted one or two for which I ask your forgiveness.
That was fine. And I think that was an excellent wrap up. And I want to see in the chat if you all are promoting and supporting that commitment that we, Justice Kukuram just read, right? That summarizes what we would have discussed, but also hearing from the participants who came today that we are committed to using those mediums to promote mediation throughout all sectors of our society. Yes, we've seen it in the chat. Thank you very much for your feedback. Thank you very much. Continue to put it in the chat. Thank you. And I just want to say it was a pleasure being here today. And we know that we have gone over time, but we really wanted to hear from you all in the breakout rooms what your feedback will be and your thoughts would be on promoting mediation across the region. And we know that you would have heard many interesting both similarities and difference across the region. And we want to be able to also commit in whatever field we are, whether judiciary, whether in policy making, whether in different societal structures, Ministry of Education, Ministry of in social services, right? We want to be able to commit where we can to change the conversation. I would like to thank our panelists today, Mr. John Bassi, Ms. Renee Batiste, Ms. Deborah Maloney, and Mrs. Beverly Harry Emmanuel for joining us today. And I would also like to thank my co-host, Justice Kukuram, who always champions and advocates for mediation in Trinidad and Tobago, but also champions, let me use the right word, champions, mediation in Trinidad and Tobago, and as a supporter of Community Mediation Services Division. I really appreciate all of your support. Okay, so we would now, you wanted to add, Justice Kukuram, closing words?
Just to thank all the participants and yourself, Rennie, for co-hosting. And it was certainly a pleasure to meet these champions. And I hope that we're all committed. And you know, it's always good when we meet like this. It just re-inspires you to continue with the good work. Sometimes you feel flat because you're not surrounded by this community. So spread the word, spread the word, spread the word, and enjoy life. So thank you very, very, very much, everyone. Well done.
Thank you. We want to go now to our poll. So we do want to get feedback from you about this conference. This is the first mediation conference that Community Mediation is hosting. And so we want to go now to our poll. We do appreciate your feedback. And as I would have indicated yesterday, we also had a survey that you would get at the end when the session is ended. It will pop up on your screen. Some it may pop up on Microsoft Explorer, but we want to go to the poll right now. So the first question, how did you hear about the mediation conference? If you're not seeing the poll, you should be able to click on more at the bottom right-hand screen and see more, and you should see the poll, or it should come up automatically. How did you hear about the conference? From a morning television show, social media, direct invitation through stakeholders, direct invitation through professional organization, Which of the Community Mediation Services Division programs have you attended in the past? Mediation, Counseling, PSG, Grief and Loss, National Empowerment Program, Men's Symposium, Peer Mediation, or none of the above? The registration process was simple. Strongly agree, agree, neutral, disagree, or strongly disagree. Using the Zoom virtual meeting platform was easy to navigate. Strongly agree, agree, neutral, disagree, or strongly disagree. Breakout room facilitators help me to understand the information shared. Strongly agree, agree, neutral, disagree, or strongly disagree. The information shared by the facilitators brought awareness of mediation and conflict resolution in Trinidad and Tobago. The information and breakout room discussion changed my perspective on conflict resolution and mediation. And number 8, so unfortunately, we weren't, the poll was stopped, right? However, you can put some of your feedback in the chat as well. Mediation is a viable option for conflict resolution in Trinidad and Tobago. And choose one of the following. I did not learn anything new. I learned something new. I learned something new that is applicable to my daily life. I learned something new that is applicable to my profession. And I learned something new and I am inspired. Yes, unfortunately, it did disappear again. I do apologize again. However, you can put it in the chat, especially with the last 2 questions. If you learned something new and you are inspired, I learned something new that is applicable to my profession. I learned something new that is applicable to my daily life. I learned something new, or I did not learn anything new. Okay, thank you all so much for leaving your feedback. Again, I do apologize, but the poll was ended prematurely, but we are still taking your feedback in the chat, and we do appreciate your staying past the time that we would have previously presented to you. But we appreciate your feedback as well as your interaction during the breakout rooms. And we want to be able to say to the persons that our leaders, that these persons are interested in mediation, that this is what the change we need across our society, that is going to be led by you, that is going to be led by the leaders, and they know that someone is interested in changing our culture from adversarial to a culture of peace. So you can put in the chat just the question, the answer to the last question. And again, I do apologize. So thank you all very much for coming. And I want to say thank you, and we will see you tomorrow, please God, where we'll be hearing how mediation is impacting communities. We have 3 persons. We are going to be hearing from our mediators at Community Mediation Services Division. We are also going to be seeing peer mediation and how peer mediation is implemented in the schools in Trinidad and Tobago, particularly focusing or highlighting rather Toko Secondary School. And we're also going to be hearing about the Ministries of Sport and Community Development National Policy for Sustainable Community Development. And finally, we will be hearing from one of our citizen mediators who was trained during the Community Inclusive Mediation Program in 2020. So please join us tomorrow. We want to hear about the impact that it has on communities. Mediation has been having on communities. We do know there's a lot of work to do, but we are getting there. Thank you, thank you, thank you.
Thank you so much, Ms. Williams. All the best for day 3.
Thank you very much.
Bye-bye.
Bye.
Thank you, Ms. Williams. Bye.
Bye, everyone.
Bye. Thank you so much for having me.